From the very moment a defendant is involved in this system, someone else has control over their story. They want to define that person solely by the crime they may have committed. When is it time for us to be able to tell our story? You have a sentencing date set, and the stakes are high. Both lawyer and client need to do everything in their power to prepare. But the question is, are you ready? I'm Doug Passon. I'm a 25-year defense lawyer, a sentencing consultant, and an award-winning documentary filmmaker. In Set for Sentencing, I'm going across disciplines and outside the box to help both lawyer and client expand their perspective, build on their skills, and get real results in the form of significantly reduced sentences. All of this in service to one goal: to bring more fairness, more compassion, and more justice to the sentencing process. So, are you ready? Then let's get set for sentencing. Set for Sentencing is a podcast we're working on. It hasn't premiered yet, but I couldn't wait because I've never seen, we as lawyers geek out on these confirmation hearings, but I've never seen a hearing so focused on federal sentencing issues than this one. So I thought we had to come on and talk about this. And this is my colleague and good friend, Mark Allenbaugh, and he is the perfect guy to bring on to talk about this because, like the nominee, Judge Ketanji Brown Jackson, Mark Allenbaugh served on the United States Sentencing Commission. Were you guys there at the same time, by the way?
No, I was there before her. And I wasn't a commissioner. I was just staff.
Your staff.
She was the commissioner. No.
So the reason I wanted to do this for just the live Facebook audience, which I'm assuming, I don't know who's on here, but I'm assuming it's mostly non-lawyers, and that's the point, because they're talking a lot, if they're going deep in the weeds on the United States sentencing guidelines and Section 3553 and the interplay between federal sentencing law and the guidelines, and nobody knows what they're talking about. And more specifically, here's my real motivation. I've been screaming at the television for 2 days now because I'm listening to people like Lindsey Graham, who's a lawyer, and Josh Hawley, who's a lawyer, and Tom Cotton, who's a lawyer, and Ted Cruz, who's a lawyer, and they know better. And they're taking this stuff and they're twisting it and throwing red meat to their base and banking on the fact that 99.9% of the people watching are going to get all riled up about child pornography and super pissed and have no freaking idea that what they're feeding them is a bunch of BS. And so I want to peel back some of the layers with you just on the sentencing system and help people understand what they're saying and why they are saying it. So I don't even know where to start, but I think that we have to start with just simply the distinction. What are the sentencing guidelines and what is the distinction between the guidelines and the law? Because the guidelines are not the law. And so just give me, like, in a minute or less, where did the guidelines come from and how are they different from the operating sentencing statute that controls under the law?
Well, back in 1986, Congress created both the Sentencing Commission and the guidelines, and actually tasked the Sentencing Commission to create the guidelines. The problem was, before 1986, at the federal level, there were no guidelines. Judges could sentence anybody to whatever they wanted to within what's called a statutory maximum. So every crime, whether it's child pornography or fraud or what have you, there is a set maximum sentence, whether it's 10 years, 20 years, or in some cases life or death, depending on what the offense is. But judges were free to put sentence somewhere, anywhere in that range, from 0 months, straight probation, 5 years, 10 years, et cetera. So there's this big disparity that everybody was upset about on both sides of the aisle. It wasn't just Democrats, it was Republicans too. It was Senators Ted Kennedy and Strom Thurmond that were the primary sponsors of the legislation that created the Sentencing Commission and the guidelines. The point of the guidelines is to create to reduce what's called unwarranted sentencing disparity, promote uniformity, and promote certainty in sentencing. So the principle is very simple: treat similarly situated people similarly. And the way to do that is to pick out what are the common denominators among all defendants in all major types of offenses, and give particular weight to them, and then pop out a sentencing range. It's a very sophisticated algorithm. Really, it's a bunch of steps that one goes through in finding out what the ultimate sentencing range is. But the point simply is that if Mark commits an offense in Arizona and Doug commits the same offense out in New York, we're going to get relatively the same sentence. It shouldn't matter what our age or our race are, or really who our judge is and what our judge's particular philosophy is. But as Judge Jackson pointed out yesterday, when the guidelines were first created, they were mandatory. So all this talk that we've been hearing about with variances and departures, that variances didn't exist and departures were very rare. I'll spare the audience the difference between the two. But what ended up happening back in 2005, and I actually wrote about this in law school, and I saw it coming.
Yeah, well, before we get, let me get there, because I pulled up a visual for everyone.
Yeah.
This is the sentencing guidelines table.
Correct.
So problem number one, from my perspective, is that people's lives and their future and their whole life story is reduced to this algorithm, this chart of numbers that you talk about. So down the left, you have offense level, meaning every case, every different kind of crime in the federal system has an offense level, base offense level attached to it. So the less serious ones have lower numbers, the more serious ones have higher numbers, and then those numbers can get higher or lower based on what we call specific offense characteristics. And this is a big deal in the child porn guidelines, which we'll get to, because there's all these little things that ratchet up these guidelines and ratchet up these guidelines. Like the use of a computer is an enhancement. So you get this number on the left-hand side, offense level, and then the top is supposedly the individualized portion of the sentencing, which means we're going to look at the offender, but all they're looking at there is whether they've been in trouble before. And so this is called criminal history. And what happens is anytime you've ever been in trouble gets assigned a point value from 0 points to 3 points. And extra points if you're on probation or parole, things like that. Then you plug in those numbers and you get a criminal history category. And where those two numbers meet on the chart, then you get this range of months of recommended punishment. So could be if you're a level 20, criminal history category 3, the judge says, the guidelines say 41, give them a sentence between 41 and 51 months in prison. And this is where you were getting to. There's a line of demarcation of 2005, which was before then, these things were the gospel. They were carved in stone. What the guidelines said, 41 to 51, that was the range, and the judge had no discretion, almost zero discretion, to deviate from that range. They couldn't necessarily go higher, and they certainly couldn't go lower. The only way they could is if there was a very few tiny little carved out exceptions in the guidelines called downward departures that almost never ever exist in a case, and so these were carved in stone. In 2005, in the case of Booker v. United States, which Judge Jackson talked about yesterday, basically, and Scalia was at the front end of this, right?
Yes.
Yeah, Judge Scalia, their beloved, the right wing, the Republicans' darling, their hero, was the one that said these guidelines are unconstitutional because they don't give the judge any discretion to deviate based on the individual facts of a case, really. And
if I may, Doug, it's a little bit more nuanced than that. What Scalia was discussing, what led to the guidelines becoming advisory, is each of those little specific offense characteristics. Every time you add a point and you're going up the chart or down the chart, as it were. The problem that he saw was that each of those little sentencing enhancements were treated really as elements of an offense. And they did not. So you did. They basically increased your sentence, and you had essentially a mandatory sentence under the guidelines. Yeah. But the government, because they were sentencing factors, the government didn't need to charge it. So people were going in and having no idea what kind of sentence they were going to get. They really had no idea what they were being charged with, and that was really the core problem. They were just being charged with a drug offense. But at the end of the day, was this a 5-year drug offense or a 20-year drug offense? Well, you really didn't know until sentencing.
Yeah. And
And
not
so,
only did they not have to charge it, but when they brought these enhancements in, the
yeah,
burden of proof was much lower. So it's
right.
much easier to prove these things. It's not there's no jury, there's no beyond a reasonable
Yes.
doubt. It's just a little bit of proof here. So
Right. So,
this was the guidelines were fair to say they were kind of a shit show before 2005 when they gave the judge some discretion to say, okay, now these things are not mandatory. They're advisory. They're one factor. The
yeah.
judge is free in any case, unless they're statutory mandatories, which we'll get to. Judge is basically almost in every single case
Yes.
free to disregard the advice these guidelines are giving.
Correct.
Now, what is the operative statute that they must consider in the factors
Well, they must
therein?
consider 3553, and 3553 is the primary sentencing statute. And what that tells judges to do, and Judge Brown actually discussed this the other day, is before Booker, they just considered the guidelines. That was it. But now they have to consider the guidelines as well as what I call soft factors or philosophical factors, such as deterrence. Judge Jackson spoke about that. Incapacitation, right? Protecting the public from further crimes, and rehabilitation, which is that last one listed there. The need for educational or vocational training. And those, I mean, the statute doesn't say how to weigh them, how much to weigh them, or really what to look at. It's just throwing out these various philosophies of sentencing and basically saying, judges, you pick. And one of the things that you should consider are the guidelines. But the
Yeah.
problem with the guidelines, though, this really started to happen before Booker, and it was with the child pornography guidelines. It's that there is very little empirical basis to them. And the whole point of the guidelines, when the guidelines were created, they were created empirically. They were created based on data. How these guidelines were ratcheted up, the commission literally went back and they looked at 10,000 pre-sentence reports, which is what I think Senator Graham was speaking about the other day. They looked at all these probation reports, and they picked out, okay, so we see how judges are sentencing cases this way, and what factors they're looking at in these cases, and what factors they're looking at, and how they're weighing them. And so what they tried to do is model that into the guidelines. But importantly, they said, we're going to keep doing this. This is a work in progress. And we know that the world changes and new laws change, or new offenses come into existence and all this other stuff. So we're going to continue to monitor how judges are sentencing, and we're going to adjust the guidelines accordingly. They didn't do that. They almost have never done that. Rather, what has happened, and it's not really the commission's fault, is Congress has come in these hyperventilating moments when there's like the offense of the moment that's going on in the media. They will tell the commission, hey, we want you to add 2 points for this, and we want you to add 4 points for that. They don't say why. They don't say why 2 points as opposed to 1, or 4 as opposed to 8, or anything like that. Congress never comes in and says, you know what, we want you to reduce the guidelines for certain offenses or for certain types of offenders either. They never come in and tell the commission to do anything mitigating. It's always ratcheting up at random times for political purposes, like we're seeing today. And so what happened now, the guidelines have become unmoored from statistics. They have become unmoored from their very foundation. And so they don't make a lot of sense anymore. And this is one thing that Judge Jackson was mentioning yesterday when child pornography came up. And Lindsey Graham was really pressing into her about the use of a computer. Do you think the use of a computer is bad in child pornography cases? And she said, of course it is.
Mm-hmm.
But what the point that he was missing is that if you have an enhancement for use of a computer and it's given all the time, then what's the point of that enhancement?
Yeah.
The point of these enhancements are to capture certain iterations of an offense, little nuances. Sentencing is a nuanced practice.
Yeah.
And so it's supposed to capture little nuances. But if it's no longer capturing a nuance, then it serves no purpose. A judge once said, and I think it's a beautiful, perfect analogy, that if you're to enhance a sentence, a child pornography sentence, based upon a use of a computer, it's just like enhancing a speeding ticket for use of a car. Mm-hmm. It's absurd. I mean, That's all the way you could commit it this way. Right. And the last thing on this particular rant is why is use of a computer only present for child pornography offenses? Why not for every white collar offense?
Sure.
I mean, but the point is, it's silly.
Yeah.
Because, I mean, every white collar offense nowadays pretty much can't be done without a use of a computer, whether it's by email or Skype or however you're doing it, wire transfer and what have you.
Sure. Absolutely. Absolutely. And so this is one of the reasons why I wanted to get on there, because it's so
Yeah.
disingenuous, the argument that they're
Yes.
making. So first of all, I think they're zeroing in on child porn because let's pick the scariest, ugliest offense to try to present a false picture that
Correct.
this judge is somehow lenient on those who commit the most serious offenses against children. So first of all, the reason we started with guidelines are discretionary because they're making a big deal that she has varied and given a less serious sentence than the guidelines suggest in nearly every single one of these cases. So let's just talk macro. After 2005, when the judges had discretion, judges wholesale on almost every single kind of case started varying and getting
Correct.
lower. So, A, that tells you the fundamental premise that the guidelines are broken. They're
Yes.
too severe.
Yes.
And judges of all stripes,
All
Republican,
stripes.
Democrat, vary. So, what is the general statistic, just generally, on how often judges are varying from the guidelines and giving lower sentences in any kind of case?
About one out of three times. One
Oh,
out of three times. And originally, the guidelines were meant to, that was to be rare. Like out of one out of every 100 times, there was going to be a departure. Now it's one out of three.
yeah.
But it differs by offenses. Just to kind of jump ahead, for child pornography, it's over half of the time.
Hmm.
Over half of the time, judges are giving sentences below the guidelines. And just on the child pornography, I want to make just one thing really clear for the audience here is there's really two types. There is viewing, and then there's the hands-on production. And those are two different types of offenses
Yeah.
that are very often conflated. And
Yeah.
really what Judge Jackson was dealing with were the viewers, the people
Yeah.
that go out and they're looking on the internet and they're finding these images. They're not producing it.
Right.
They're not engaged in contact offenses or anything like that. A
Right.
lot of people think that
Right.
if you're looking, you must be touching. As you know, there's tons of psychological peer-reviewed articles and literature about that, where there are two different types of animals: those that view and then those that actually
Yeah.
touch. But I'm getting a
Well,
little.
no, you're not, because that's another way that they have been deceiving and misleading
Yeah.
the public. Because, first of all, they're lumping in those two categories
Yes.
and very deliberately. And if you look at language, for example, by Tom Cotton, I have a question that he asked. He says, should we strengthen or weaken sentences for child pornographers? And he's not, when he's asking that question, he's not distinguishing between looking at pornography or producing. Now, is anywhere in the lexicon could you ever consider someone who views child pornography to be a pornographer?
No,
A
no, they're not
pornographer is
creating.
someone who creates it.
Correct.
But
Exactly.
over and over and over again. And Marsha Blackburn did it, same deal. Do you think that it matters the victim's motivation of the pornographer? They deliberately use this word pornographer to suggest that people who view this are pornographers. Now, the other thing that they did was ignore the studies and the science. And what they basically said is, if you're looking at it, you're a pedophile.
Yeah.
And so, translation, Judge Jackson, you're soft on pedophiles, right?
Right.
Okay. The research says very clearly that just because you are looking at this, you have an interest in it, you have a curiosity about it, it does not mean that you are a pedophile.
Correct.
By any scientific definition, and certainly does not mean that you're going to commit a hands-on offense against a child. Isn't that right?
That's right. And there are tons of studies that support that. Even the commission itself is on record in several reports now. One that just came out a few months ago, noting that there's this big difference that those that view are a completely different animal than those that actually engage in production offenses. But the other thing I want to add just quickly too, before I forget, and I wish this was mentioned, I wish somebody had prepped Judge Jackson on this, and frankly, she should have known this. And forgive me if she did articulate this, But the Department of Justice itself is on record in writing that the child pornography guidelines for viewing need to be ratcheted down, need to be readdressed. And they agree. The Department of Justice in writing agrees that an enhancement for use of a computer is stupid. It serves
Mm-hmm.
no purpose. It's just
Mm-hmm.
artificially inflating the offense conduct for no sound reason.
Mm-hmm.
And that's the other thing that the guidelines are all about. And we want our justice system, or criminal justice system, to be rational and based upon principles. That's kind of the whole point of the rule of law.
Yeah.
And if it's not rational and if it's not based on principles, then it's demagoguery.
Yeah.
And then you're in North Korea or you're in Russia, something
Well,
like that.
and today, just before we got on, Senator Graham was putting on his dog and pony show for the second time, and Judge Jackson was trying very eloquently to explain to him that, because the computer age and the difference between before child porn, before computers and after, you could click on one button and download 10,000 images, right? And so just because you've done that doesn't necessarily make you as culpable as the guy who's ordered it through the mail 10,000
Right,
times.
right.
And she said something effective, and if you have those 10,000 images, you could be looking at 30, 40, or 50 years in prison. And Lindsay started saying, "Good. That's exactly what we should be doing. Good, good." And I'm thinking to myself, you sick person, like, you think in any realm that it's appropriate to put somebody in prison for the rest of their life because they looked at some pictures online, as bad as those pictures may be,
Right,
as
right.
harmful as it is to children to create those images. What public needs to understand first and foremost is the actual pornographers, people who are creating this stuff, never get light sentences. They get
Yeah,
their asses handed to
right,
them.
right.
I've never seen someone get less than 15 years, but usually it's 20, 30, and up to life, because
Correct.
they're the ones hands-on abusing the children
Correct.
and everything else.
Right.
And so what the proper response is, Senator Graham, is we are not here to just judge the crime. We're here to judge the person, that every case is unique and every human being deserves some degree of individualized consideration to determine what the punishment is for them.
It's nuanced.
And it's very nuanced. Now, I want to talk about the idea of deterrence, because this is another thing that they manipulate,
Yeah,
ignore the studies, and
right.
ignore the truth about deterrence. First of all, like lumping pornographers and lookers into one category, they lump general and specific
Yeah,
deterrence into one category. So Lindsey Graham was yelling today about, you don't think it deters someone to put their asses in jail for as long as possible? Fine, that's called specific deterrence. If you want to deter one person from going online and watching porn, yeah, they probably can't do that from a jail cell. But what we're really talking about is general deterrence, meaning how do we let the public understand that if you do this, there's going to be severe consequences. Now, I got to go back to Tom Cotton, because again, this person knows better, and if he doesn't know better, then, well, he should, because he's supposedly an intelligent human being. But his first question out of the gate yesterday, and he was so disrespectful in
yes.
his tone and his mannerism, it made me sick, right? So here's the question. He says to her, and this is another instance where I thought she was kind of caught a little off guard because she didn't have the right answer ready at her sleeve. But here it is. Is someone more likely or less likely to commit crime if it's more certain that they will be caught, convicted, and sentenced? And the answer, the studies tell us, is yes.
Mm-hmm.
A person is less likely to commit a crime if there is certainty that they'll
Yes.
be caught,
Right.
convicted, and punished.
Right.
But here's what the studies say. It is the certainty of punishment, not the severity of
Yeah.
punishment, that deters people from committing crimes.
Yeah.
And Tom Cotton knows this, but he didn't talk about it. I wish the judge would have
Well,
had
right.
that.
And one of the things just on that point,
Yeah.
in terms of severity, how severity does not serve as a general deterrence, look at our country. we incarcerate more individuals in the United States than the rest of the entire world, than any other country in the entire world. Over 25% of the world's prison population is here in the United States. Yet we make up less than 5% of the world's population. So we have a disproportionate amount of prisoners that we put in for prison longer than any other country on earth. And yet we still have a high recidivism rate.
Mm-hmm.
It's not the severity of the punishment. I mean, it's just plain as day looking at it.
Right.
We have so many offenders and everybody's so disenfranchised. We
Longer
do not
sentences,
have
longer
yeah,
sentences,
the sentences do nothing. The severity of the sentences, I should say, well, except in a small handful of cases, they do nothing to deter the offense.
Yep. And Tom Cotton said, this is a bunch of, quote, elite lawyers who think sentences for child pornographers are too harsh. No, it's 1 out of every 2 judges on the American bench
Correct.
who think these are too harsh. And by the way, again, he used the word pornographers, which nobody thinks those sentences are too harsh. And like I said, if you're making the porn, you're dead in the water. But if you're watching the porn, none of the people of those 10 cases that the judge sentenced avoided prison. They all went to prison, some for a little bit of time and some for a lot of time. But if you look at the truth behind federal sentencing policy, the fact that they're going to prison at all meets the deterrence factor. But they're not going to tell you that. They're just going to bang the drum about, we have to be tough on crime and sentence these people to as long as possible. And I got to tell you, what really sickens me is you and I handle, and for those of you who don't know Mark, you'll see a lot more of him as we go forward with Set for Sentencing, because we've already recorded another podcast episode. I don't know when it's going to drop, but Mark's whole area of expertise is in sentencing statistics and the sentencing guidelines. So he knows this stuff inside and out. But what we do is we do handle a lot of these offenses that are related to child porn, especially just the viewing of child porn. And a lot of the cases that I handle end up being online offenses with people who are on the autism spectrum. And this is a perfect example of why these guidelines are a blunt, dull, horribly offensive tool, because if you just followed that chart and you didn't take into consideration this person has, a neurological difference that really did interfere with his ability to understand the moral and legal ramifications of his conduct. Oh, and by the way, if you put this person in prison, they're going to be abused like you've never imagined, and with sights and sounds and smells and clothing and the foods that they can't eat and how manipulated they'll be by other prisoners. And if a judge is not considering all those human factors behind a sentence and reducing a sentence because of that, then what is our system at that point? It's I don't even want to think about it. And Tom Cotton did the same thing. He went into murder. And he talked about the severity of punishment. And he goes, the average murder sentence in our country, and I don't know if he's talking federal guidelines at this point or not, but he goes, the average murder sentence.
A lot, yeah.
Oh, yeah, totally. Because the average person isn't going to know. He said the average murder sentence is 17 years. He asks, is that too long or not long enough? And I'm like, how could you answer that question? Is this a first-degree murder?
Yeah.
Is it a second-degree murder? Was there an imperfect self-defense claim? Was there, mental issue? Like, there are a million factors that go into that. So it's just such a bullshit premise.
And murder, and just in that, murder, as you know, is a relatively rare offense federally, at the federal level. Yeah, and frankly, for that matter, so is child pornography. Child pornography offenses make up only about 3% of all the sentences every year. The bulk of federal sentencing is immigration, drug trafficking, white-collar offenses, and firearm offenses. Those four offense types, that's about 2/3 of all federal sentences in any given year. So all this about murder and all this, we're talking about very small areas of sentencing law.
But that's the most sensational one. So before we move, I'm glad you mentioned drug offenses, because I want to talk about the compassionate release motion they brought up with the drug case. But Before we do, there are a couple other things I think people should know, because one of the things they went through, Ted Cruz had a chart, and he had her 10 child pornography cases, and 3 months was the lowest sentence she's ever given in a case, and 120 months was the high. Except for there were some cases that had mandatory minimums where she couldn't give less than 60 months.
Mhm.
And that was, so first of all, they made a big deal about, well, first of all, what the public needs to understand is the first person in this process who gets to start to set the parameters that a judge has to work with, what sentence she may be able to give in a case, is who?
The prosecutor,
Why?
they charge, and how they charge, what
How
type
they
of sentence.
charge,
Right.
and then what plea bargain they offer, right?
Correct. Correct.
Because they may charge a case as a mandatory minimum. And child porn is a perfect example of how prosecutors have discretion to manipulate the sentences just based on the charge. So, for
Yes.
example, there are actually a couple of different variations on the looking theme of child pornography. One is just possessing it, which means you've downloaded it to look at it. The other is what most of these folks do is they share it. I've got some and I want to give it to you. Well, if I send you something and you send me something, it's not like trading baseball cards. It's called distribution.
Right.
So at that point, you're a distributor of child porn, even if you share it with someone.
Yeah.
And
Which
but
are,
that's got to
but on that note, the distribution enhancement, when it was created, it was back in the 90s. And by distribution, then they meant somebody who was physically a distributor, creating and shipping off child
right,
pornography,
right,
not in the modern era now, sharing
right.
it on your, through software.
Right. Which what's all we do all day, every day on a computer is
Right.
exchange information.
Correct.
So, yeah, but that is a mandatory. If you get charged with distribution,
Mhm.
that's a mandatory minimum sentence, right?
Correct.
Of 60 months.
Yes.
So basically, most people who are possessing it have probably committed the distribution crime, but the prosecutor has discretion, A, whether to charge distribution and kick in that, oh, you're going for at least 5 years no matter
Right.
what happens, or B, maybe they charge it, but they could plea bargain that away and plead you just to possession so that the judge then has some discretion. She doesn't have to start at 5 years and go up from there. So
Right.
do you see in this process how much power the prosecution has to start to shape that sentence before Judge Jackson or her cohort ever get their hands on this case?
Right.
So the public doesn't understand that. So I think that's important. The other thing they need to understand, because Ted Cruz and these people made a big deal about how her sentences went below what the prosecutors recommended at sentencing. So each side gets to say what they think the sentence should be. And the truth of the matter is that's an irrelevant point of
Yeah.
analysis.
Right.
And the reason is, I don't know if this is your experience, but this is my experience. The prosecutor is almost always going to recommend a sentence that's within the guideline range.
Correct. Yes.
So even though the guidelines are discretionary and the judge doesn't have to follow it, and they deviate one half the time in these types of cases,
Yeah.
I'd love to know the statistic. We don't have it, but I would say probably 90% or more of the time they just recommend. They may recommend a low end of the guideline, a high end, but they're going to stay within that guidelines all the time.
Correct.
And
Correct.
so to that extent, they're sort of their recommendation becomes sort of irrelevant in the sense that the judge knows what the guideline is. They know
Right.
the prosecutor is going to stay in the guideline, and they're going to do what they think is right no matter what. So
Right.
I don't care what the prosecution recommends, and the public should bear no weight in
Right.
this analysis.
Right.
Along similar lines, they made a big deal about, well, what does the probation office recommend?
Yeah, that confused me why they were getting that. That seemed like a red herring. The probation officer, as Lindsey Graham rightly noted, is just an independent arm of the court. And what basically the probation officer does is collect all the background information on the defendant, and where is he from, education, medical issues, psychological issues, all this other stuff, as well as information about the offense conduct. And then does a guidelines calculation that the judge doesn't have to follow. the judge could actually come up with a different calculation. And I'm not talking about the judge following the guidelines or not, but the judge may not always agree with an enhancement that the probation office might give. The judge is free to say, I don't think this enhancement applies here, or maybe this other enhancement does, and stuff like that. But it's
And
just
and what's your experience in terms of the recommendation? A probation always makes a recommendation about what the sentence should be. What's your experience about whether they're ever going to recommend something outside the recommended guideline range?
well, first of all, it varies by district. Sometimes the probation office does give a recommendation to the judge. Sometimes no, there's no recommendation. These are the guidelines, and do with them as you will. And I am actually seeing more cases now in those where POs, probation officers, are recommending making a sentencing recommendation. They are at least starting to identify grounds for downward variances, such as the defendant's age or health conditions or the lack of criminal history. And this is, that as you pointed out earlier in our discussion, criminal history kind of only goes one way. More and more criminal history, worse sentence, But what if you're really clean and this is the first contact you've ever had? The guidelines don't give you any type of reduction for that. As a true first time offender, you
Mm-hmm.
just start off normally.
Yeah.
And so I'm seeing now, because of a lot of recidivism studies and stuff, the POs now are getting a little bit more sophisticated. They're saying, Judge, you might want to consider that. If this is a first time offender and maybe there's no victims involved in this particular type of offense, and you might want to cut a break here. So
Yeah.
I'm seeing that more. Not frequently, but I'm
Yeah.
seeing it more often.
Yeah, a little bit. But I think as a general rule, when they are making recommendations, they're sticking pretty much with the guideline sentence too,
Yeah.
in my experience. So the fact that she's giving less than the probation recommended, another red herring. I agree with you 100%. And then the only other aspect about pre-sentence reports, they made a big deal about they weren't disclosed, and we don't have them, so we don't know what the probation office even recommended. Well, first of all, who cares? Like we said,
Yeah.
it's a red herring. Second
Right.
of all, these are the most private, privileged
Right.
documents in the criminal system. They're not available in the public record.
Right.
There's a bold print right up top says, if you're not the lawyer in the case, you better not share this.
Yeah.
It's got,
Defendants can't even get them in prison.
yeah.
Defendants are not even entitled to their own PSRs.
So it's the Senate. So I'm guessing if they really tried, they could get their hands on these. But it ain't easy. So to
Yeah.
suggest there's some nefarious
Yeah.
motivation for keeping these secret is again utter bullshit. I'm sorry, and the public needs to know that.
Yes.
All right, so this is fun. We've been doing this 40 minutes, so there is now, I think, just basically one more. Well, last note on the child porn. I left terrified because what they're banging the drum, and it's back to this tough on crime. The guidelines are not. The judges have too much discretion. The guidelines are not serious enough. Whatever. So I can't help but now be terrified, especially if the Republicans get back control of the House and the Senate, which they likely will, if we're not going to start seeing some really horrible legislation that ratchets up, that takes away discretion, ratchets up, more like they're going to do something horrible with these guidelines, and they're already broken and horrible as it
Yeah.
is. So while I'm overjoyed about this pick and the historical nature of it. And by the way, we're not just talking about the fact that she's the first African American woman on the bench. She was a federal public defender,
Correct.
which is near
Yeah.
and dear to my heart because you don't see defenders elevate to the bench nearly as much as prosecutors, almost never.
Yeah.
And
She's
yeah,
the first since Thurgood Marshall. She will be the first public defender on the bench since Thurgood Marshall.
yeah. And I love that because
Yeah.
I was a federal public defender.
Yeah.
We're the exact same age. She's 50, she's 51, and I was 12 years as a federal defender, and it is a magnificent job. It's a magnificent office. These are some of the best lawyers that I've ever worked with, smartest, most dedicated, hardworking lawyers. And without defenders, the system of justice collapses
Correct.
on itself.
Yeah.
So the fact that we've got her going to the Supreme Court, I'm overjoyed. But I'm
Yes.
worried about what the blowback's going to be from from the other side. Anyway, so let us talk about one more really interesting thing that came up yesterday, and it was from Tom Cotton,
Mhm.
and he talked about this case of a drug kingpin who was a fentanyl dealer, I guess, and went ballistic. And you know this case. You're familiar with this case, right? Or no?
No, no, I'm
Okay.
not.
So, okay. So basically, this was a compassion. This came up at sentencing.
Okay.
I don't know why he was calling him a kingpin. It was just the fact that he was dealing drugs and it was fentanyl,
Mhm.
which is bad. Fentanyl's bad.
Yes.
Nobody,
Yeah.
everybody who's listening,
Right.
fentanyl's bad. No, don't do fentanyl. You'll die. But he was subject to a mandatory minimum of at least 20 years in prison. And Judge Jackson, looking at the whole individualized picture of this man,
Mhm.
said, shit, I don't want to send this guy to prison for 20 years. It's too much for this crime, right?
Mhm.
And lots of judges feel that way. They
Yeah.
hate mandatory minimums because it takes away all their power to do the right thing in a
Right.
case. And
Right.
she literally looked at him and said, I'm sorry. I
Mhm.
don't think this is an appropriate punishment, but I have to give it to you because that's
Yeah.
the law. And she gave him 20.
Yeah.
Now, flash forward and COVID, well, there was a change in the sentencing laws in the interim that would have given him a lower
Correct.
if it, do you know what they're talking about there, the
The retro
tweak to the,
the retroactivity.
well, it wasn't retroactive, but they changed one aspect of the sentencing guidelines, but they didn't make it retroactive.
but
And
didn't the
I don't
First Step Act make it retroactive?
uh well, that's a good question. Tom Cotton seems to think it didn't, but the
Okay.
point was,
Yeah.
and I don't think it did either.
Okay.
But I'd have to look it up. But point is, flash forward, change in the law, but it's not retroactive. But COVID happens,
Right.
and he files a compassionate release motion,
Mhm.
which the First Step Act, and the
Which
what's
I
the
think
other one?
Tom Cotton voted for.
Yeah, right. And so what this says is if you are really, really at risk in prison, because federal prison's not there to help stop the
Right.
spread of COVID and treat
Right.
you medically. So if you're really high risk, you could seriously die. You drop dead from COVID in prison.
Yeah.
So people start filing these motions for what's called compassionate release. And what it does is it allows you to get back in front of the sentencing judge to get either lower your sentence or get released or released on home confinement or released on some probation. And this gentleman filed the motion, gets back in front of Judge Jackson, and he had some risk factors for COVID, but they weren't that serious. And she said, I'm not releasing you on COVID, but she took what we call a second look at his original sentence and said, if you were before me right now on
Mhm.
this exact same case, under these exact same facts, I would not have had to give you 20 years, which I
Right.
didn't think was appropriate at the time.
Mhm.
And so she reduced his sentence and by about seven, I think by about 7 years. So he ended up getting 13 years or something. And Tom Cotton was going ape shit ballistic over this. And so talk to me about, and he was basically saying, and this is why I want to clear up the record, that what she did was inappropriate, that this was there for COVID, but she ignored the COVID and reduced the sentence on other grounds. Is that inappropriate?
That not only is that not inappropriate, but compassionate release actually has been part of the guidelines. It was in the guidelines enabling legislation from back in 1986. Compassionate release has always been there, but it's been rarely granted. It's been rarely given because it was all dependent upon the warden at your particular prison. And the inspector general for the Department of Justice, as well as the Sentencing Commission, I mean, the Sentencing Commission has always been bipartisan, has said that compassionate release was not being granted enough. And so what happened, the last presidency, the last administration, the Trump administration, they passed the First Step Act, which now allowed the defendants themselves, inmates themselves, to go before a court. They didn't have to rely on a warden alone to get compassionate release. And the reason why they passed the First Step Act is they wanted more compassionate release. And this was a Republican Congress that passed this legislation. And it was bipartisan too.
Hmm.
So no, it wasn't inappropriate. Tom Cotton just forgot that he thought it was appropriate. That's what happened because he
I
voted
don't
for the
think he
legislation.
forgot.
Yeah,
I
I
don't
know.
think Tom Cotton forgets
I'm
anything.
being facetious. I'm being
Yeah,
facetious. But he's yeah.
but there has been some litigation below whether these what they call second look cases are legit, meaning okay, maybe the grounds for compassionate release on COVID aren't legit, which Tom Cotton said. He did acknowledge that compassionate release has been around, but here's what he said: lots of criminals like this one have tried to twist the First Step Act to get out because of COVID. So this is just a big scam. COVID, compassionate release motions based on COVID is just a big scam. But anyway, the point is, when you get back for a compassionate release, the law says you have to go back to 3553, the
Right.
operating sentencing statute, which requires the judge to look at the nature and circumstances of what? The offense.
Right.
It requires the judge to look at the history and characteristics of the person. A judge can look at their conduct in prison for the 10 years that they've been sitting in that hellhole.
Right.
And have they been in trouble? Have they done great programming? How have they
Right.
rehabilitated themselves? So, again, to take a judge to task for looking at the human being behind the crime in the way that she did makes me sick. And
Right.
so I
And just one
think,
thing
yeah,
I'll add on, just
yeah.
real quickly to add on that
By the
point.
way, I just got a news flash. Madeleine Albright passed away just
Oh,
now. Anyway,
mm.
go ahead.
Okay. So, with respect to compassionate release in the second look, before the guidelines, we had something called parole, and many states have parole, and that happens all the time. And this is basically what it is. It's, in essence, a parole, a second look, and that's what parole has always been about. Now, when the guidelines were created, that was done away with, but now it's back in at least a very restricted and structured form. But that is what it is, and that's the whole point of compassionate release. So he is being quite disingenuous, especially since he voted for the First Step Act.
Yeah.
Yeah.
Yeah. All right. So I think those were the big things that stuck in my craw. I don't was there anything that stuck in your craw that I missed that we didn't talk
Well,
about?
the only thing that has stuck in my craw is that I recall at both Justice Gorsuch's and Justice Kavanaugh's confirmation hearings, relevant conduct came up a lot. I don't recall that being discussed with Justice Barrett, but those two, there was a lot of discussion of relevant conduct. And if there was ever a justice or a potential justice to speak to relevant conduct about it at a confirmation hearing, it was Judge Jackson. And I don't recall any of that discussion coming up. And the problem is for your audience about what relevant conduct is. It basically means that any information can come in, just about any information can come in at sentencing to ratchet up your sentence to make it worse.
Yeah.
And there's no rules of evidence. Hearsay can come in, stuff that normally would never see the light of day at a trial can
Yeah.
come in at sentencing to
I'll
make.
give you an example. In
Yeah.
a fraud case where I committed mortgage fraud and I'm charged and convicted of defrauding a bank, they could bring in an old lady from 5 years ago that I may have sold a bunk magazine subscription to and never got charged, never got convicted, and the evidence is very minimal to it. But they could bring in any other instance of fraudulent conduct and try to weave it into the same general scheme and pattern of behavior.
Right.
And sometimes it's very closely related, and other times it's very tangentially related.
Right.
And why it matters, not only does it paint a person as a horrible person, but the guidelines in a lot of these cases get ratcheted up substantially, especially in fraud cases, by the dollar amount. So
Right.
you may only be charged with fraud of $10,000, but if they can find all this other stuff and not have to prove it, but it ratchets you up to $1 million,
Right.
what do you
Right.
do with that?
Right.
Yeah, so that's relevant conduct.
Yeah.
Sorry, go ahead.
Well,
So,
yeah.
and you
So I mean,
said she's most suited to talk about it. What do you mean? Why do you
well,
think
because
that?
she was a commissioner. She was the vice chair of the Sentencing Commission,
Yeah,
and that's something that the commission has always talked about looking back at is the use of relevant conduct and reining it in. And
yeah,
they've never done that. And the other
yeah,
thing too is like the standards of the standard of proof at sentencing is only a preponderance of the evidence. That was temporary. that was meant to be temporary, just a placeholder back in the 80s, and they were going to look back at it again. And maybe it's time to have a higher standard of proof. Well, it's long past time for that. And I wish they would have asked her these questions, because that could give us some insight into where the Supreme Court might go, because these cases keep coming in front of the Supreme Court and they're not granting cert in them. They're not looking at them. And I think it's far past time to start looking at the procedural due process, or really the lack of procedural due process at sentencing.
Well, and along the same lines, acquitted conduct
Well,
is relevant
right. That's
conduct.
like the hallmark of the big problem.
You could go to trial
right.
and be found not guilty of certain charges, and they could still use it to enhance your sentence at sentencing.
Correct. That's just mind-boggling.
The guidelines are so broken.
Yeah.
You bring up the prior Gorsuch and Kavanaugh, and I can't help they especially Lindsey Graham invoked the horrors of the Kavanaugh hearing. And by the way, Ted Cruz, and I know this is going afield, but Ted Cruz on his podcast said that the Democrats are much harder on the Republican candidates, and said we would never bring up someone's high school dating conduct during a hearing. And I'm like, oh, you mean the credible accusation of rape that you would like to call high school dating conduct? So shame on you, Ted Cruz. Shame on you, Lindsey Graham. Shame on you, Tom Cotton. You know better. I'm not going to say shame on you, Martha Blackburn, because she's a home ec major and an event planner, and I do not know how she failed her way onto the Senate, let alone the Senate Judiciary Committee. I don't expect her to know better. But these guys know exactly what they're doing, and they're playing their base. They're playing to their base, and it's dangerous. But I can't help think about Kavanaugh and how he reacted to these questions, and watching Judge Jackson and she just handled this with such grace. She was 12 hours just getting punched in the face yesterday. So I'm so glad she will be confirmed, and I'm over the moon about it. So anyway, that's my 2 cents. I would say if anybody had any questions to ask us, there's 5 people on. Hi, Peter Kaplan, Laura Carpenter, Jason Molnar. You're a lawyer. You got to have something to say. No? Okay. Well, I guess that's it.
Okay.
Well, thanks, man. I appreciate you. For anybody who tuned in late and they're wondering who the heck this handsome, buff gentleman is, Mark Allenbaugh. He is a colleague. He's a friend. He's an attorney. He is sentencingstats.com. He is, I would say, the world expert on sentencing stats, especially federal sentencing stats. So he had a great perspective to bring in. Thank you so much for being here. And for anybody who is tuning in, I hope this was helpful. And we'll see you next time on Set for Sentencing. Take it easy, man.
Okay.
Bye.